Let's say you have money and I have food. And then we agree that you will pay me your money and I will give you my food. We all know this example from our introductory video to contract law, and we know that the agreement that we made, in legal terms, is called a contract. But let's dive deeper. What exactly did we do when we made that agreement? Well, in very broad terms, we exchanged promises. You promised me to pay me your money and that benefits me. Meanwhile, I promised to give you my food and that benefits you. This forms a contract between us, and if either of us decides not to keep our promises under this contract, the law will make us keep them. Now, we know that the law is really serious about contracts. At a deeper level, the reason for this is that contracts usually create win-win situations, and the law loves those. That's what the doctrine of consideration exists for. Very broadly, it ensures that only contracts which create win-win situations can be enforced by the courts. Under the doctrine of consideration, before the law is willing to enforce a contract, the parties to it must provide some kind of value. In legal terms, it is said that the parties to a contract must provide consideration for it. Whoa, okay, so that was probably a lot to take in. Let's go back to the earlier example to get a better idea of what's going on. Now, let's say that instead of us agreeing to exchange money for food, you simply promise me that you will pay me money for nothing in return. And of course I'm going to agree to that. Then, of course, you realize this may be a stupid idea, so you break your promise and decide not to pay me the money for nothing in return. I then take you to the courts, argue that you breached our contract, and demand that you keep your promise. If this situation sounds ridiculous to you, that's because it is. I mean, even if our agreement was really serious and perfectly legitimate, there's something wrong about forcing you to keep your promise in this situation. That's the doctrine of consideration in action. The law will only enforce contracts which involve some exchange of value. And in this case, there's clearly no exchange of value because I'm giving you nothing at all in exchange for your promise. So in legal terms, I did not provide consideration for our contract, and the law will not enforce it. Well, okay, so under the doctrine of consideration, contracts must involve exchanges of value. Naturally, the question that follows is this: what is valuable in the eyes of contract law? The thing is, on this point, the law is a little weird. Generally, it might seem that anything which is vaguely valuable could count as valuable consideration. And here's 3 pretty weird examples. Let's say you promise to marry someone in exchange for money, but you already would have married them for free. The Shadwell and Shadwell case says that there's consideration there because your marriage benefits a third party. Or let's say you promise your uncle that you'll give up your bad habits, and in exchange, he'll pay you some money. Your uncle hasn't benefited at all from your promise, but guess what? Those are exactly the facts of the Hamer and Sidway case, where the court found that a bearing of detriment also counts as consideration. Even better, let's say that in exchange for your promise to give me your car, I promise to pay you $1, and you agree to it. This isn't just valuable consideration in accordance with the Chappell and Nestle principle. It's actually common practice in the commercial world. With all that having been said, you might wonder if there are any situations at all, other than promises for nothing in return, of course, where consideration may not be found. Well, there's one. Let's say we agree that you'll pay me $5 for my food. Then you realize that you only have $2 in your wallet, so you ask for a variation agreement, where you'll pay $2 instead of the original $5 for exactly the same food. The law would say that you had provided no consideration under this variation agreement because you had paid less for exactly the same thing. You might then ask if the same idea applies when you agree to pay more for the same thing. Funny enough, it does not. So on this point, stay tuned for my case summary of the Williams and Roffey Brothers case. But we'll be talking about just that today. In today's video, we talked about the very unusual doctrine of consideration, some interesting examples where consideration was found, and why there's no consideration in the situation where you pay less for the same thing. I really hope that this video was helpful for your understanding. Consideration is an incredibly technical topic based on a very simple idea. So if you're ever confused, just keep in mind that at its core, consideration is about the exchange of value. Of course, if you're a law student, the fun has only just begun, so don't forget to do your readings as well. But for everyone out there, law students and non-law students alike, hope you have a great day ahead, and stay safe.